Harani Law Circle மாணவர்கள் அனைவருக்கும் வணக்கம். I welcome you all back once again to our channel, and this is Advocate Frederick. This session is part 11 of our target to complete 50,000 multiple choice questions in law. If you haven't seen our previous 10 parts, I request you to visit our channel's playlist or check out for the links in the description box. These 50,000 multiple choice questions will help you crack any legal examination which is conducted in your state or in the national level. Be it the civil judge examination, judicial magistrate exam, special legal officer exam, or even the district judge examination, you will be able to put your 100% in your performance. These 50,000 questions are divided into 1,000 parts to make it easy and comfortable for you to prepare. The only favor that I request from you is, I want you all to share this session or our playlist to your students, friends, juniors, or students who are preparing themselves very sincerely, and those who are not able to afford for these examinations, like if they are not able to afford for the coaching or to attend a proper mock test. So I want you all to share these videos especially to those students so that they will also benefit from the same. I assure you that these 50,000 multiple choice questions is more than enough to crack your preliminary examination in your state or in the national level. So with that end note, I would also request you to subscribe to our channel so that you also don't miss even a single part of this session. So without wasting much of a further time, let me start with the first question of this session. Which of the following sections of the Transfer of Property Act 1882 contain exceptions to the maxim nemo dat quod non habet? So this is a legal maxim. So the options given to you in the bold letters is the answer to the question. I have specifically given you the answer directly in bold, or I would have marked it separately, highlighted it, because it is not a way that we read long PDFs together and prepare ourselves for an exam. So I have directly given you the question, what is expected in your preliminary examination. You might come across the same question with the same options in your examination. So that is how I have framed the questions to each of these sessions. So in that way, it will be very helpful to remember directly what the answer is by looking at the question. So section 41 and 43, option D is the correct answer. We should know what the maxim says. So nemo dat quod not habet literally means no one can give what they do not have. So it is basically used in the property law terms. So this particularly means that a person cannot transfer a better title than what they possess. So the general rule which is applicable to this legal maxim is that a person who is not the owner or who lacks authority, he cannot transfer ownership of the property to some other one. Am I right? See, I don't have a property and I'm not the legal owner of the property, and I don't claim any ownership to the property, but I transfer certain property to you. Is that a valid transfer? No, right? But with certain exceptions. So one such exception to what I said right now is transfer by ostensible owner, where the person who transfers the property might not be the real owner, but it appears that with the consent of the real owner, the ostensible owner transfers the property to some other person. And the transferee, the person who receives such property, he receives it in good faith and he takes reasonable care to ascertain the authority of the transfer. Once he does all these things, such transfers are also valid under section 41. So this is an exception to it. So moving ahead to the second question. Remedy of foreclosure is available in which of the following mortgages under the Transfer of Property Act 1882? So when I say remedy of foreclosure, so foreclosure in basic terms in case of loans is that, so you foreclose a loan is symbolically you settle some debt previously to the date what you stated earlier. So keeping aside the legal literal meaning of what foreclosure is with respect to loans, coming back to property law, foreclosure means, see, a mortgagor mortgages some property to the mortgagee. So just first listen to me so you will understand it better. A mortgager mortgages some property to a mortgagee, and in return he receives some money for his emergency, whatever. Thereafter, there is a conditional time which is mentioned in the mortgage, that if on non-payment or a default on payment happens on the mortgage, the mortgagee has certain powers to apply to the court and get permission to foreclose. So this is a remedy which is given to the mortgagee by conditional sale. So the mortgage by conditional sale is the answer, where there is a condition precedent. On default of payment, the mortgagee has a right to approach the court to sell the property in case there is a default. And the redemption right which the mortgager has is now not available to him. So that you can see in the legal explanation below. So just pause for a while, read it, and move to the next question. So the third question: a municipal board under a resolution gave possession of land to X and Y with the right to make construction on the land, subject to the condition that after termination the construction shall belong to the municipal board. X and Y accepted the condition and made the construction. What is legally created? So you don't need to confuse about the question, which is in 3 lines. Just divide it into multiple parts. So what this particular question simply says is that a municipal board had some possession of a land and ownership of the land, and now this municipal board gives it to X and Y to construct something. And on termination of the construction, on the completion of the construction, now the property which X and Y built together has to be given back to the municipal board. Such a condition is laid down. So this condition, what is the legal nature of this such condition of construction? So is it a lease, or is it an usufructory mortgage, or is it a license or an easement? So the correct answer to this question is option C, as you see in bold letters. Answer is license. So we need to understand what is license first of all to understand the question and the other terms associated in the options. So when section 52 of the Indian Easements Act 1882 says what is a license, where it is a right granted to a person, that is X and Y, to do something on another's immovable property. So this another is the municipal board here, which would otherwise be unlawful without transferring any interest in the property. See, in case municipal board did not give any condition to X and Y to construct some property, and X and Y on its own anonymously constructs a property and gives it to the municipal board, is it legally lawful? Is it lawful? No, right? So which would otherwise be unlawfully means if this particular transfer of interest in the property, the possession is not being transferred, a permission to construct is only given. So the transfer of permission from the municipal board to that of the X and Y is the interest that is transferred in the property. So such a kind of transfer makes it a lawful act, thereby making it a license being granted. So do you get the point? So the landmark case with reference to this particular situation is Associated Hotels of India Limited versus R.N. Kapoor, which is a Supreme Court decision, where it held that if the document gives only a right to use the property in a particular way or under certain terms, while the legal possession remains with the owner, it is a license. Moving ahead to the fourth question. Which of the following is an immovable property under the Transfer of Property Act 1882? The equity of redemption, a hut, mortgage, debt, right to recover maintenance allowance charged on immovable property. See, we have options 1 and 2, 1, 2 and 4, 1 and 4, 2. So in these kind of questions, even if you do not know the answer, see, we have the answer in bold letters, 1, 2 and 4 are the right answers. But I'm not, see, if we do not know the answer and we try to approach the question, so our first step should be elimination. So elimination gives you more marks in case you don't know the answer at all. But I don't think so that will happen once you complete all these 1,000 parts. But still, I'm saying 1 or 2 questions might come out of this 50,000 multiple choice questions. I'm giving you the confidence to crack those questions as well. So in this situation, we see that there are three options which say one is the correct answer. So the probability of being correct, one being correct, is at large, right? And when considering option D, two only. So is two an immovable property? A hut. Yes, a hut is immovable property, right? It is attached to the ground. It is attached to the earth, as the property law says. Anything attached to the earth and it is not removable through normal means, then such kind of attachments to the earth are known as immovable properties. Saying so, 2 is an immovable property now. We know that option D is correct, but is option D only correct? That has to be considered again. So now we see that two options which has 2 as an option is a correct one. Then C is obviously wrong. So write down C. Then considering A and B, they are correct. And we have one in both A and B. So one is also right. So equity of redemption is an immovable property. Yes, it is a immovable property. A hut is a immovable property. Yes, hut is an immovable property. But now we have a confusion whether the right to recover maintenance allowance charged on an immovable property, whether is it also a immovable property or is it a movable property? Now, maintenance allowance, many students confuse themselves by looking at vague terms like maintenance allowance charge. So, maintenance allowance is something that is of money or it's not of something which is immobile. So, it is not an immobile property. So, don't go in terms of that opinion. So, they have clearly mentioned to you in the option that right to recover maintenance allowance charged on immovable property. See, if an immobile property is not there at all, what would be the situation of the right that one person can recover maintenance allowance from that property? No right. There is no right at all, right? So only when there is a immobile property situated in a particular place, a party would have the right to claim or recover maintenance allowance. Otherwise, there would no right that would occur in that situation. So, right to recover maintenance allowance, which is charged on an immobile property, is also part of the immobile property. Do you get the point? So, in that instance, B will be the correct answer. Even in cases where you confuse yourself with right recovery of maintenance allowance and you think otherwise, you would come out with a very minimal amount of probability that A and B are correct, either A or B. So the probability of choosing B will be 50% and the probability of A would be 50%. So comparing to the probability that you need to choose one among four and you need to choose one among two would be more. So in that way, you will be on a positive advantage side, right? So think of questions and options wherein you need to choose between the alternatives. Don't panic in the exam hall because you will have limited time and think wisely before deciding anything, even if you don't know the answer. So this is the explanation that is given. I want you to skim through the explanation so that you will have a confidence and clarity on the question. Moving ahead to the fifth question. Which one of the following statements is not correct? So I want you to focus on questions where they say incorrect, correct, non-correct, not correct. So basically these headlines matters a lot. Sometimes what students do is they read the points and directly they choose some question which they feel it as correct. But the question might say you have to choose the not incorrect option. So in that way, don't make such mistakes. And here the incorrect statement is option B. Let's read through all the statements. That is what I recommend all the students to do usually. A transfers a farm to B for her life. And if she does not desert her husband to C, B is entitled to farm during her life as if no condition had been insisted. So this is the way you need to cut statements and read to understand it better and faster. You don't need to reread it to understand it so that you don't consume much of your time in the exam hall. And option B says A transfers 50,000 to B on condition that he shall marry with the consent of C D, and E. Now, what B does is, B marries without the consent of C, D, and E, but obtains their consent after the marriage. The condition shall be deemed to be fulfilled as it had been substantially complied with. C. A living person can transfer the property to himself in present or in future. A vested interest is not defeated by the death of the transferee before he obtains possession. As we read through these statements, example B, as we read, we can understand that there is a condition that the consent should be obtained before marriage. And what B did is, he got the consent after marrying. Okay, so absolutely the condition is not fulfilled. How come it would be correct? Do you get the point? They say that it is substantially complied with. That is the loophole where the examiners score and you lose. So substantially complying and complying fully or of same nature. They don't find much. We don't find much difference between what we substantially comply and what we completely fulfill. Do you get it? So in that way, option B is the incorrect statement, wrong answer. So it is basically void in nature. So section 25 deals with conditions and transfers and what condition precedent is illegal and what condition precedent can be impossible, what condition precedent can be an immoral or which is opposed to public policy. So when a condition precedent is illegal, which is impossible in nature, immoral or opposed to public policy, then such kinds of condition precedents of transfer fail automatically. They don't have the legal holding. Moving ahead to the sixth question. For an acceptance, mere mental resolve to accept would not be sufficient. There must be some external manifestation of the intent by speech, writing, or other act. See, when you accept something, your mental condition to accept is not alone sufficient for acceptance. There must be some external manifestations like your consent of speech. Yes, I accept, sir. Such kind of actions, or by writing, yes, I accept, or by any other act that gives the offerer the word that you accept. Such kinds of manifestations should be there to externally give your intent. So mere mental thought to accept does not mean acceptance. So this particular statement was given in Bhagwan Das versus Giridhari Lal and company. Okay, option D is the correct answer. Now looking at the explanation, we could see that this particular principle is behind the law of acceptance, and it also says mental assent. The thought to accept alone does not constitute acceptance, and some outward expressions like verbal, written, or by a conduct of the parties who accept should be there, and the offerer should be aware of the acceptance. The internal decision to accept is not alone sufficient to bind the parties to the contract. If it is not communicated externally by words or actions, it is void basically. So the other cases which were there in the options are also usually asked in various examinations with regard to contract law. I want you to have a small recap of all those points as well. Fazal Eli versus East India Railway Company. It deals with different contract principles, not to a specific particular provision. So such type of questions might not usually occur. M. Nanjappa versus MP Muthuswamy, more on offer and revocation. So when particular situations where questions are asked on revocation, and this particular M. Nanjappa versus MP Muthuswamy is given in the options, just choose it. Dugdale versus Lowring, a classic English case, but not about this exact principle. Okay, moving ahead to the seventh question. Doctrine which requires that the transferor must deliver the subsequently acquired property to the transferee who acted upon his false representation and did harm to himself by paying money for what he could not get is called feeding the grant of estoppel. So option C is the correct answer. So we need to understand what question 7 says. But before understanding what the question itself says, we need to understand what feeding the grant of estoppel means, right? So feeding the grant of estoppel is debarring, stopping a person from not acting otherwise. For example, let the transferor assure a transferee. See, I am in case of a sale deed, I am the person who is selling the property. Okay, and there is a person who is buying the property, who is called the purchaser. And this person who sells the property assures the purchaser that the seller has the title to the property, and on assurance of that, the transferee, that is the purchaser, is he transfers the payment on paying certain sum of money or performing any act. He intends to receive the property through sale, through the purchase. In this situation, now it is subsequently found that the person who said or assured to sell the property to the transferee did not own the property, but subsequently, after the transfer, he acquires the property. In such cases, the transferor is legally barred, is stopped from denying the transfer to the transferee. So this is what simply it says. So in this way, the transferee will reduce his loss which he suffered during this transfer. Do you get the point? Even if you don't understand, I'm ready to repeat it. I'll once again repeat all the things together now. A person A is a person who transfers the property to a person B. And this person B, believing that to be the title of A, on his assurance, pays some amount or does some act in return for a consideration. Done. Now B has to get the property in his hand, right? He has to get the possession of the property. Now what happens is that it comes to the knowledge of B that during transfer, A did not have the property. And later on, subsequently, A acquired the property through some means. Now B has the right to claim the property for the loss which he suffered. Okay, now A, who sold the property through a transfer, is legally barred from denying the transfer. He cannot say that I got the property and the transfer was null and void, and you cannot claim a property that I did not have during my transfer. Now you have the property, right? It's mine. So that is what B will say. So this is the rule which is established by the explanation feeding the grant of estoppel. So other options relating to the question is that rule against unjust enrichment. So this principle is basically to prevent one party among the parties from taking unfair benefit on the expense of the other. One party suffers and the other party getting unfair benefit from the sufferance of the other party. So to avoid such kind of unjust situations, so this rule is generally practiced in courts. The next one is implied consent. So implied consent is an inferred consent from the conduct of the parties. For example, you offer something to me and I accept through my conduct, and it implies that there is an implied consent, a consent which can be inferred from the conduct. And the third point is doctrine of substantial compliance. So on fulfillment of certain conditions to a certain degree, to a sufficient degree of situation. For example, there is a condition precedent and you complete the condition for around 90%. And then the person who contracted you with the condition says, no, I am not giving the property as you did not fulfill the 10% of it. That cannot be validly approved as condition was not fulfilled because the doctrine of substantial compliance was satisfied. So this is also a rule through precedents as we generate, we come to know. Eighth question, which section of the Transfer of Property Act was amended in the year 2002? So the answer to this question is section 106 of the Transfer of Property Act. So 106 deals with leases of immobile property, where the time period 12 months after which there should be a registered lease deed. So that needs to be done. So this will strengthen the registration process and it will protect against the third parties who forge documents. So section 106 was amended in 2002. So you need not understand, you need not deep dive into the concept, just a basic overview of what 106 says. So it says about mandatory registration after 12 months of any lease deeds, lease agreements. Next, 9. In case of gift, if the donee dies before acceptance, then. So this is very simple question. The only thing you need to understand is I give some donation to a child, and when I give the donation, the child is no more. The child died. So what is the purpose of giving the donation to some random person? There is no use, right? So when I give something, that donation should go to the child for the benefit of the child, for its education, for its well-being. But if it dies, there is no use in me giving the donation at all. So donee is the person who receives, who is in the receiving hand. So when a gift is donated to some person and the person who receives, that is the donee, dies before his acceptance, then the gift itself is void. You cannot say that it is gifted and you don't have any right to the property. The gift itself is void. Okay. So option B is the correct answer. Moving ahead. So I want you to read this part. Section 23 says about this provision. 10th question on your screen. Which is the right of the mortgagee and not that of a mortgager? We saw this in this session itself. So the right to foreclosure, which is given to the mortgagee. And the mortgager is barred from redeeming the property which he mortgaged. So just skim through this explanation as well to get a better understanding to the question. Moving ahead, 11th question. Damages allowed under section 73 of the Indian Contract Act are compensatory damages. B is the correct answer, compensatory. So section 73 basically deals with damages and more specifically compensatory damages. So what section 73 says is that compensation for loss or damage caused by breach of contract. You agree to some party through a contract, you offer something and the other party accepts it and there is a consideration behind it, and now there is a condition which the contract has and you breach it, and out of that breach either of the party incurs a loss or a damage. Breach means you don't comply with the conditions. That is what is called as a breach. You don't comply with the conditions and there is a loss or damage to one of the parties. And now the other party has to compensate for the loss incurred or the damages incurred by the other party. Do you get the point? Simple. Next. 12. Assertion A, reason R. Yes, we have assertion and reasoning question. Such kinds of questions are also asked here and then. A stranger to a contract cannot enforce a contract. Obviously, it is true. Myself and the students who are watching this video, we get into a contract. And there is some party C who comes out of nowhere stating, see, you did not do the contract and you breached the contract. You need to give me compensation. Can a stranger to a contract enforce the contract? No right. He has no right. We both have, I have given you an offer and you have accepted me on the offer and we both have a consideration, whatever. But what is the purpose that C gets into the contract and says something and tries to enforce it? No. So option assertion A is true. Reason, he is not party to the contract and cannot take benefit. Obviously, he is not party to the contract. And how can he take benefit from the contract? No. Reason is also right. So option A is the correct answer. A and R both are true and R is the correct explanation of A. So this particular example is taken from the doctrine of privity of contract. which states that privity means, so it makes it a private contract. Okay, in simple terms, not literally. Only parties to the contract can sue or be sued on it. Only parties to the contract can sue or be sued on it. A and B gets into a contract. A can sue on B or B can sue on A. Otherwise, no stranger, C, D, E, nobody can get into the contract and enforce such kinds of contract. Enforces to mandate a condition to be done or to omit such conditions. Moving ahead to the 13th question. We have two lists. Therein, list 1 we have few case laws, and list 2 we have certain principles to the contract law. And we see that Satyabrat Ghosh versus Mugniram is given, Raj Rani versus Prem, Entos Limited versus Miles Corporation, Harvey versus Pese. You would all have read about Harvey versus Pese in your college days, if you would remember. But other provisions, yes, Satyabrat Ghosh is a very famous landmark decision. Raj Rani is also a landmark decision. Entos Limited versus Miles Corporation is not more specifically mentioned always in the contract law. Here and then it is mentioned in certain books. But Mainini, as usually students read in during their semester times, they don't find Enters Limited versus Miles Corporation in Mainini. So in that way, they would feel it difficult to answer this question. But still, we know what Harvey versus Paces is. So Harvey versus Pace is in the initial part of the contract provisions. Even if you have forgotten all these case laws, you can just try to answer it. So Harvey versus Pace is one kind of landmark decision where students, you all would have read it in the initial part of the contract law. So it can be in relation to the invitation to offer. Okay, if you the only thing which I say right now is, if you have forgotten what it says, if you remember it, well and good, hats off to you. Harvey versus Pace is related to invitation to offer. So D is with respect to 1 in list 2. So coming to the options, as we see, D has 1 as an option in only option D. D is the correct answer. So you have to just memorize what these landmark decisions say with respect to the principles. And I have also given you what is the explanation with respect to list 2. Doctrine of frustration means contract which became impossible to perform due to unforeseen events. There was a contract which was possible during the time of the contract, and after a certain period of time, there was an uncertain event which happened, due to which the contract which was already entered between two parties are now impossible to be done. Then such kind of contracts would come under doctrine of frustration. Giving an example, a person who entered into a contract with B, stating that you have to marry C. You have to marry C only with the consent of D. A person gets into a contract with B, stating that B has to marry C only with the consent of D. Now D dies. What will happen? The unforeseen event is D dying. So after D dying, there is no possible option for B to marry C at any point of time. The contract becomes impossible to perform. So such kind of contracts are doctrine of frustration. Minors agreement, which deals with contracts involving minors, communication of acceptance, all these are easy to understand stuff. I want you to read it. 14. Difference between a contract and social agreement is that of. So there is a social agreement and there is a contract. What is the difference between these? Intention to create a legal relationship is the difference. Let's look at the explanation, so that by reading the explanation, you will also get along with me in understanding the question and the answer. A contract is legally enforceable agreement between parties. Yes, it is legally enforceable, which requires an intention to create legal relations. Yes, the intention is there. Without this intention, the agreement cannot be enforced. Yes, intention is an important aspect in creating legal relations, which is also enforceable by law. If such intentions are absent, agreements cannot be enforced by law because there is no legal relationship between two parties. On the other hand, a social agreement is such as those which are made between friends or family members, generally lack intention to create a legal relation. So therefore, even if the parties agree on terms or provide consideration, such agreements are not enforceable in a court of law. Let's take for example, I have two sons. Let's take for example, I have two sons, and the property which I have was not my self. So there was a call which interrupted me. That is why there was a delay. So I transfer such property to another party, like one of my sons, not to both my sons. I transfer my property to one of my sons, and the other son of mine goes to the court and claims the property. Obviously, the court will divide the property to both the persons. Only in case of will, I can transfer a property to either of the sons, and that too, it should be my self-owned property. But in case of an ancestral property, I cannot do such kinds of acts. So the intention to create legal relationship is not enforceable in the court of law. So you cannot create a legal relation through a contract. It is a social agreement. It cannot be enforceable by law. Done. So a contract can be done, or an agreement can be done on something which is mutually available to both the parties, or in case of family relations. So you cannot enter into an agreement which forbids another party into the family from not enjoying such property or that act specifically. Do you get it? Moving ahead to the next question. Which one of the following relations does not come within the undue influence relationship? So looking at the question, we know on the screen that B is the correct answer, but we need to understand why B is the correct answer, right? So looking at the options, doctor and patient, lawyer and client, master and servant, customer and shopkeeper. Here, the obligation to act upon some decision of someone who is in the position of dominance is the point of undue influence, basically. So when someone need to unduly influence you, the other party should be in the position of dominance. He needs to dominate you. Only then an undue influence can be done. So coming back to the options. So looking at option A, we can see that the patient needs to follow the instructions what the doctor says. If he does not follow what the doctor says, obviously he is going to face issues in his health and safety. So the doctor is in the position of dominance where he can unduly influence, right? Okay, second one, customer and shopkeeper. A customer gets into the shop and the shopkeeper may suggest to buy some clothes, but it is not the obligation, or the customer is not obliged to act upon the suggestions of the shopkeeper. The customer can choose between what he wants to buy, or he may quit buying also. He may leave the shop without buying. So in such situations, the shopkeeper has no right of dominance, or he cannot unduly influence. He is not in a legal position to act in such relationships. Next, coming to client and lawyer, lawyer and a client. So in case of issues, the client comes for a legal opinion and the lawyer grants a legal opinion, and the client now has to act upon the advice, aid and advice of the lawyer. In cases where he does not act upon the opinion, he gets into another trouble. So there is a aspect of dominance where he can unduly influence. So there is a relationship. in such nature. Master and servant, obviously, as the master dominates the servants and makes them do work. So customer and shopkeeper is the correct answer. So undue influence is basically defined in section 16 of the Contract Act, where it refers to a situation where one party is able to dominate the will of another and uses that position to obtain an unfair advantage in a contract. So certain relationship naturally gives rise to such dominance, which includes doctor-patient, lawyer and a client, master and a servant. These relationships involve trust, confidence, or authority, which can lead to undue influence. In contrast, customer and a shopkeeper relationship in a normal commercial transaction where no special trust or dominance exists, here it does not fall within the scope of undue influence as per section 6. Moving ahead, point out the incorrect statement. So one of the following statements are incorrect. As we know, C is the incorrect option. Let's read through all the options to understand better. A party who rightfully rescinds contract is entitled to compensation for his damages. Yes, two parties get into some contract, and there is one party out of which who wants to rescind the contract. Then he is entitled to compensation for the damages which is caused to the other party, right? So A is correct. Where a person gives any bond for the performance of any act in which the public is interested, he shall be liable upon its breach to pay the whole sum mentioned there. So there is a contract between a bond between two parties. One party executes the bond on a performance of act which affects the public in case such act is not done, or if such act is done, in case if you need to not do it. Then if there is a breach, of the condition, then the person who breached is liable to pay the whole sum which is mentioned according to the contract on its breach. So it is also correct. Option C. A party to the contract complaining of the breach is not entitled to receive any compensation from the other party if no actual damage or loss is proved to have been caused thereby. D. The rule of compensation for loss or damages caused due to the breach of contract contained in section 73 of the Contract Act does not apply to void agreements. So we saw in question number 13 about section 73 of the Contract Act, where we saw that certain agreements like an illegal contract or a contract which is immoral in nature, or contracts which are impossible in nature, such contracts are void agreements, so that they cannot be enforced. So in case of any breach of such contracts which are impossible, or which are not able to be performed, or which are immoral in nature, or which is illegal in nature, so in such situations any loss or damage incurred to the other party may not be compensated. That is not a rule of compensation. Okay, so option D is also right. So what is wrong with option C then? Let's look into the explanations in detail. So the option C says a party to the contract complaining of the breach. So now there is a party AB. So where one of the parties complain complain of a breach. There is a breach which happened due to either parties non-performance of a condition, and either of the parties complain on the contract. So such complaining party is not entitled to receive any compensation from the other party if no actual damage or loss is proved to have been caused there. So is it necessary for the other party to prove such loss or damage caused by the breach by the other party? A and B get into a contract. Now B says, I am not ready to continue the contract. Now there is a breach, and due to which A incurs some loss or damage. Is it really necessary for A to prove that a loss or damage was caused? So such criteria is not necessary. So it is incorrect. Do you get it? It is not dependent upon the proofs. That is the point I want to ensure. Question 17. A contingent contract dependent on happening of a future uncertain event can be enforced when the event happens. So a contingent contract is that you mention a specific condition on an uncertain event, and on such uncertain event happening, the contract will be enforced. Such kind of contracts are called as contingent contracts, basically. So the explanation will give you more detail. Section 32 deals with contingent contracts. Moving ahead to the next question. A owes B rupees 5,000. A pays to B rupees 2,000 and B accepts it in satisfaction of the whole claim on A. Here, whole debt is discharged. So this literally makes us look weird, right? But this is the point where B gets satisfied or accepts what the due which B owes to A or A owes to B, right? According to this question. So this in real time situations, as you can see in there are various agencies where they deal with bad debts. If I have to explain what bad debts is in economic terms, so you get some loan from some bank and you don't repay the loan back within a period of more than a year. You don't pay back the loan, even the principal or the interest associated with it for more than a year. Then what happens is the particular debt which you need to pay to the bank becomes a non-profitable. It becomes a bad debt, basically, right? We usually call it in economic terms as NPA, right? And non-performing assets. So these non-performing assets or bad debts, as we call usually, so these debts are bought by certain companies after a period of time. For example, after a period of 2-3 years, even if the person who does not repay, they sell these to certain companies like Reliance, non-performing asset reconstruction companies. So there are multiple companies who deal with these particular bad debts. So they get these bad debts or non-performing assets by a sale from the bank. Then what they do is, for example, you take a loan of 5 lakhs and you are not able to pay back the loan to the bank. The bank considers it as a non-performing asset after a period of time. Okay. Now what the bank does is, even after multiple notices to you, you are not ready to pay. The bank will not go through litigation route. Always. Not always. It might go to the litigation route, but in certain situations where the court feels it that litigation would be more expensive than extracting the debt from you, it will sell those non-performing assets to companies like Reliance, or there are various companies associated like this. So what these companies will do is, you get a loan for 5 lakhs and the interest with the, along with the principal comes to around 8 lakhs and you don't repay it back. The bank will sell it to the companies for an amount of 2 lakhs. And what the company will do is, they will buy it for 2 lakhs from the bank and give the bank 2 lakhs. And after which, the company will force you through notices or a lump sum prepayment. They will request you for a lump sum prepayment on a settlement basis for within 6 months or 1 year. They will not give you long period like banks. Banks usually they give you 10, 20, 30 years, right, to repay a loan with the interest. But these companies, they give you a minimum period of 3 months, 6 months, 9 months, or 12 months to repay back at one settlement or 2, 3 settlements together. So in that way, these companies earn. So it is accepted by these companies to forego certain sum and accept only a particular part of the sum which the other party needs to repay. So being in keeping that in mind, so when we read through this particular question, we can understand that A now owes B rupees 5,000 and A pays to B only 2,000 and B accepts it. He has no problem in accepting the 2,000. B accepts it and he is satisfied for the whole claim. I'm okay, I'm satisfied with the whole claim. Then this situation, in this situation, does A fulfill the entire debt or is it only partially discharged? So that is the question. So the answer to this question is the whole debt is discharged. It is only based upon the acceptance of the other party on the debt. So section 63 of the Indian Contract Act says so. Moving ahead to the 19th question. A contracts to sing for B at a concert and gets 1000 rupees as advance. A is too ill to sing. Here, A is bound to sing, A is bound to compensate B for loss, A is bound to return the amount advanced. None of the above. So, returning is better, right? You promised B to sing, but later on you are ill and you are not able to sing in the concert. It is better that you repay back the advance you got from B as soon as possible. You know that you are ill and you are not able to sing. So this is a real time situation where a common man can um, decide what to do. 20. Under section 124 of the Indian Contract Act, contract of indemnity includes losses caused by human conduct, losses caused by accident, losses caused by natural calamity, none of the above. So section 124 deals with losses caused by human conduct. So what it says is that a contract by which one party promises to save the other from loss caused to him by the conduct of the promiser himself or by the conduct of any other person. Therefore, indemnity under the Indian law is restricted only to losses caused by human conduct, acts of promiser or third parties. So it does not cover losses which are caused by accidents or natural calamities. So it is only through human conduct. 21. Unlawful consideration and object have been mentioned under which section of the Indian Contract Act 1872? Just now we saw the provision, unlawful considerations, section 23. Moving ahead, 22. Agreement without consideration is void. Yes, agreement without consideration is void. Consideration may be because the valid conditions of an agreement is there needs to be an offer and acceptance through consideration. So without an agreement without a consideration is void, obviously true. Consideration may be given by promisee or any other person. Yes, consideration can be given by the promisee or any other person who acts upon the promise. It is also true, but this does not give this does not give the reason for an agreement without consideration is void. So the possible reason which can be given is that the consideration is considered void because an agreement under the Indian Contract Act defines an agreement as such. It needs to include consideration. This can be a possible reason, but not that this statement says consideration may be given by promisee or any other person. It does not have anything to do with the consideration becoming void or not with an agreement. So both A and R are true, but R is not the correct explanation of A. Just fact check these questions with the explanation given below. Moving ahead to the 23rd question. List 1, which has certain situations which happen in real time, and list 2 has principles with respect to those situations happening. Let's code into it. A railway ticket table, or railway timetable, or railway timetable. So a railway timetable, is it an offer? Like, is it an invitation to offer? Does the railway timetable, which is displayed in the railway station, does it invite you to get onto the train and board the train or take a journey? No, right. The railway timetable is just It just gives you an information of what the timing is and how to proceed with your due course. It doesn't give an offer to you. It just shows at what time you can go. So it is only when you go to the ticket clerk, go for a request or put an offer to him asking a ticket to some place. For example, if you want to go to Taramani, which is here in Chennai, from beach station, then you need to ask the ticket clerk who is sitting in beach station for a ticket to Taramani, and he renders you the ticket. So he accepts the ticket and he renders you the ticket. So the general offer is asking the ticket clerk for a ticket. So that is where a general offer gets into place. But a railway timetable is basically an invitation to offer. So these are the train timings. You can choose one among them and ask me for a ticket. Okay, it is an invitation to offer. Invitation based upon invitation to offer, you cannot claim that it is an offer and he did not accept it. You accepted it and he did not give it. There are situations where what happened is like there are train timings which is displayed on a board, and due to certain situations the train does not arrive due to some track issues, or it can be due to some reconstruction work which is happening across the lane, and this person goes and asks a ticket to the ticket clerk, and he says, no, no, sir, we are not providing tickets now. Then the train is cancelled and we are not providing tickets. And this person who was rejected of the ticket goes to the court and says, see, they have given the railway timetable of on what time which train would arrive at the particular station. And on asking the ticket clerk rejected the ticket and he is not ready to give me the ticket. So in such situations, the railway timetable cannot be considered as an offer. It is only an invitation to offer. The time when the offer happens is when you go and ask the ticket clerk for a ticket. The acceptance happens when the ticket clerk says, yes, sir, I am ready to render the ticket and here's your ticket. So now the acceptance happens and the consideration is you pay for the ticket. It can be 5 rupees or 10 rupees. You pay for the ticket. So that is when the consideration happens. And the free consent is there. The free consent is you voluntarily go and get the ticket and he voluntarily renders you the ticket. So there is a free consent. There is no undue influence. There is no coercion. There is no force. So this is when a proper contract happens. Am I right? So a railway timetable is merely an invitation to offer. Public notification, yes, obviously it is an offer. There is a public notification which says there is a 2000 vacancies for a particular post, and you accept to that particular vacancy and you apply to that post. It is a offer. Public notification is an offer. And what kind of offer is that? It is a general offer. It is not particularly limited to few people. It is given to a wide range of people. So it is a general offer. Moving to the next point, picking up an article from shelves and putting it in the basket in a self-service mall. You go to a supermarket, you take a particular product from the shelf and put it into your basket. It is an acceptance of an offer. The ad which these supermarkets show on the TV, all these are an invitation to offer, and the shop itself keeping those products on the shelves for sale is an offer, and the act of taking a particular product and putting it in your basket is an acceptance to the offer. So this is how it should be understood. Next, coming to point D, A says to B that A's offer is not accepted. B should say no immediately. B keeps silent. In such situations, it is not the acceptance of the offer. So option B is the correct answer. So I have explained to you in detail, so there is no use of staying on the explanation page. If you are not sure about the explanations, Just pause and read it. 24. A promise to pay a debt barred by the law of limitation. So you promise to pay a debt which is barred by the law of limitation has been made enforceable under which section of the Indian Code? So the correct answer is option C, section 25. So the general rule under section 25 is that an agreement without consideration is void, as we saw in the assertion. There is an exception to the rule where section 25 lays down certain agreements that are valid even without consideration. So now it goes against our basic knowledge, right? So these are points where you need to focus more. There might be situations where your reasoning or assertion questions might include not all agreements without consideration are void. So in such circumstances, you need to understand about section 25 and the exceptions which underlie in the Indian contract. Section 25 says a promise made in writing and signed by the person to be charged therewith or by his authorized agent to pay wholly or in part of debt of which the creditor might have enforced payment but for the law of the limitation of suits is valid. So with respect to the law of limitation, such suits may be valid. Okay. The example is given below with respect to the exception. If you are not clear about it, I want you to read the explanation example which is there below. It will give you a clear meaning as to what the exception says. So don't worry. Moving ahead to the 25th question, and we are in the mid of this session. The salaries and allowances of the judges of Supreme Court of India are charged on. So the judges and salaries of the judges and judges of the Supreme Court of India and the allowances are taken from which fund? So it is a consolidated fund of India. It is under Article 112, Clause 3 of the Constitution of India itself. Question number 26. Order of the Election Commission to cover statues of elephants. Section election symbol of the political party during election period. So the election commission usually what it says is you need to cover statues of elephants or a political leader. For example, if it is Tamil Nadu, covering up of the statues of MG Ramachandran, our ex-chief minister, or Kalangar, as we usually call him, Karunanidhi. So covering the statues of these people, does it amount to some violation of the constitution? Does it violate? So the answer to this question is it does not violate. So covering up of these statues can be legally valid and it is constitutional. It does not violate Article 20. So have a read through of it, not a big deal with this question. 27. In which list is the subject pilgrimages, places outside India enumerated? Pilgrimages, places outside India enumerated. So if someone needs to enact a law with respect to the pilgrimages, which are places outside India, not within India. For example, pilgrimages of the Sikh community, which is in Pakistan, as we all know. So enacting a law with respect to such pilgrimage is under the union list. The state does not have any power to enact any law or legislate a law with respect to the pilgrimages which are outside India. So it is in entry number 20. 28. P.A. Sangma versus Pranab Mukherjee 2023 was decided by the Supreme Court. So they are asking The question has been framed in such a way that you need to know the majority on whose side the case stood and who were the judges who dissented to a particular judgment. So the answer is option B by a majority of 3:2. So let's dive into what the case says. So the parties to this particular case was Purno Akichok Sangma, PA Sangma versus Pranab Mukherjee, which was a 2012 to 13 decision, wherein an election petition challenging Pranab Mukherjee's eligibility under Office of Profit criterion was into question. So the five judge bench of the Supreme Court of India was set up. The outcome was that the petition was dismissed, and the court held that Mukherjee's election as the president was valid. So he was not under any office of profit, and the election of Mukherjee as the president was absolutely valid. So this was decided by 3 people out of 5, and the 2 were the people who dissented and said, yes, Pranab Mukherjee had an office of profit and he was not eligible to be elected as the president, and electing him is void. So it was not an anonymous decision. Moving to question number 29. In Banumati versus State of Uttar Pradesh, it was a 2010 case, the Supreme Court, in interpreting Article 243C of the Constitution, applied which of the following doctrine of colorable legislation, doctrine of silence, doctrine of pith and substance, doctrine of basic feature. So the correct answer is option B, doctrine of silence. Many students might not have come across such a kind of doctrine. So this is where you get into a lock. You might think that such doctrines don't exist at all, but yes, there are many doctrines that you might not have come across in the Indian Constitution. I just want to put light on those particular doctrines in my sessions. Yes, obviously the other doctrines will also be discussed here and then, but such doctrines which are not in visible light get more importance with respect to examinations. So Article 243C of the Constitution deals with the powers, authority and responsibilities of panchayats. More specifically, in Banumati versus State of Uttar Pradesh, the Supreme Court examined the validity of state legislation on Panchayati Raj matters, where the Constitution is silent on certain aspects of state legislative powers concerning Panchayat Raj institutions. The court applied the doctrine of silence, which holds that if the Constitution does not explicitly prohibit the state from legislating on a particular matter, then the state legislature may do so, as long as it does not violate the constitutional provisions. So the Constitution, the state, the union is being silent as long as the state legislature, the Constitution does not say thus such legislation which is passed by the state government is in violation of the Constitution. So in such circumstances, the Constitution does not prohibit the state from legislating such acts with respect to Panchayati Raj institutions, which are local government institutions, as enumerated in Amendment Act of 73rd Amendment, Constitutional Amendment, right? So this doctrine helps fill gaps where the Constitution is silent, especially in matters of concurrent or residual powers. So residual powers means other powers which are not specifically mentioned in the union list or in the state list. And the other doctrines which are in the options are mentioned below. I just want you to read through it, and in case there is a future question which arises in our sessions, I'll explain it in more detail. Question number 30. In which of the following cases did the Supreme Court hold that Section 125 of the Criminal Procedure is applicable to all persons irrespective of their religion? Muhammad Tajuddin versus Komaruddin Begum, Muhammad Ahmad Khan versus Shahbanu Begum, Teja Singh versus Choto, Miss Stora Khatun versus Muhammad Ibrahim. So the correct answer is Muhammad Ahmad Khan versus Shahbanu Begum. So the Supreme Court ruled that Section 125 of Criminal Procedural Code is only of secular nature and it applies to the all citizens regardless of the religion. So Muslim women cannot be denied maintenance under Section 125 even if their personal law allows only limited maintenance. So this provision aims to prevent vagrancy and destitution, ensuring fundamental protection for all spouses. And the other thing I just want you to tell was I have planned to organize a new session like these 50,000 multiple choice question series for the mains part, especially for the mains part, wherein we are planning to take around 1,000 questions, thousand descriptive questions for our analysis, and I will give you the exact answers that you need to write in the examination. Uh, you can memorize it, you can understand it and disseminate, or you can do your mnemonic uh, knowledge, or you can choose any kind of structure that your mind accepts and put into practice. And I'll explain you each question word by word, and I'll make you understand entire topic that which is most essential for your mains, and through which we would be able to complete our descriptive part also. This is also given to you free of cost, no charge, nothing at all. Okay, 1,000 questions direct to you on our channel. So stay tuned to that too. I want you all to follow and have a look at those videos as well, so that it is not that your preliminary part decides your future, your mains particularly decides your exam, right? Preliminary is just a qualification part. For that you have to struggle to a limited time, but for mains you need to prepare a lot, you need to practice a lot, you need to write a lot, you need to learn a lot. Not of situations where you read through some multiple choice question like these and you just come across the same question in your exam. You just have to write it, you need to memorize stuff, right? So for that I'm getting you this 1,000 questions which are very 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 important, where you will get all the questions in your examination only from those 1,000 questions. 1,000 questions which is equal to all questions in your mains. Simple as that. So I'm planning to do it. The team is working on it, and I'll get you back on that on a later video, on a separate session of how the video will go and how the session is going to be. And coming back to our session of part 11, 31st question on the screen. The power to grant anticipatory bail under section 438 Code of Criminal Procedure vests with who can grant an anticipatory bail under section 438? Both the Sessions Court and High Court. Moving ahead. 32. In case of general offer, there is no need to communicate the acceptance if it is not required by the proposer. The principle has been held in Carlyle versus Carbolic Smoke Ball Company. So it is with respect to the Indian Contract Act 1872. So the facts is given above. It is related to influenza, which is contracted by Carlyle Smoke Ball Company after using their product, and the conditions were not fulfilled. 33. Under Section 182 of the Indian Contract Act 1872, National Textile Corporation Limited is a government department, an agent of the central government, not an agent of the central government, an agent of the central government if the president consents. So this corporation is not an agent of the central government. 34. Under the Code of Civil Procedure, an appeal may be filed by way of application, petition, memorandum, notice. The correct answer is memorandum. So it can be filed through a memorandum. So Order 51 Rule 1 of CPC provides that an appeal from any original decree passed by a civil court shall be preferred by filing a memorandum of appeal. Similarly, appeals under various provisions of CPC are initiated by a memorandum of appeal. So, what is a memorandum of appeal? So, we need to understand what is a memorandum of appeal through which we can file such applications. So, it is a formal written document in which the appellant, the person who appeals, he states what are the grounds of the appeal, what is the relief he sought in the appeal, what are the facts of the case, and it serves as the official notice to the lower court and the respondent also. And the appellant is challenging the decree now. 35. The judges of family court cannot be considered for elevation of as a high court judge. The Supreme Court held this in which of the following case? Correct answer is option D, SD Joshi versus High Court of Judicature at Bombay. So a judge of a family court cannot be considered as a judge for the elevation to the High Court. So the reason behind this is judges of family courts are deal with cases more specific to family based, family oriented matters like maintenance. They deal with very few provisions of law or very few acts. They don't entertain a variety of matters. So their nature of practice is very limited. So in such circumstances, being elevated to that of a high court judge may not be possibly benefiting situations where an environment case is being put up in the high court, or wherein a case where a civil appeal or a criminal appeal is being instituted in the high court. So that will be a difficult task for them without practice. So that is the reason they choose among the district judges to be elevated to the high court. 36. Which one of the following sections of the Code of Criminal Procedure 1973 deals with the High Court's power of revision? So High Courts have power of revision. So under which section of CRPC is it dealt? The correct answer is option B, section 401, 401. So 401 says that the High Courts to call for the records of any case from the subordinate criminal court. So it is to examine the correctness, the legality, or the propriety of any finding, sentence, or order. So the court can automatically they have the inherent powers to call for records of those cases. And TPC also has such a kind of provision where the High Court can get or call for records of civil matters, and the lower court is it does not stop, it does not bar the lower court from not deciding the case. It can go ahead with the case. Calling records does not bar the lower court, the subordinate court, from not disposing of the case. It can dispose of the case at its own wish and will if the procedures are complied by law. Next. 37. Which of the following provisions is related to set off under the Code of Civil Procedure 1908? Set off is discussed in Order 8, Rule 9. So, set off is to change the ruling of the judge. For example, a judge rules ex parte. Thereafter, the other party who was infringed of the judgment he can apply for an setting off the ex parte decree which was passed, and again put back the case into the position where it previously was. So it is mentioned in order 8 rule 9 of civil procedure. 38. Which one of the following is not a kind of agricultural lease? Lease for cultivation of indigo, lease for cultivation of vegetables, lease for rearing tea plants, lease for gathering fruits from trees. Option D is the correct answer. Lease for gathering fruits from trees. See, I have multiple things to explain to you for each question, but but I don't think there'd be much time for me to explain at this point of time, because there are various questions where you can come across the other explanations as well along with my question. So that is the reason I limit my explanations to a particular point. I don't extend my explanations out of the topic. Moving ahead, 39. One of the most important principles of law of evidence is that evidence is to be weighed and not to be counted. This principle has been incorporated under which section of the Indian Evidence Act 1872? So the correct answer is section 134. It has to be weighed and not counted. For example, there is a evidence which has witnesses. There are around 10 to 15 witnesses, for example, for a particular case where it says this is the person who killed this man, and those all those 10 to 15 evidences are situations where they did not see them properly. They did not see the person who killed properly, and they were at a distance of around 20-25 meters, and it is not clearly visible during the dim light. So even if there were 10 to 15 witnesses who said this is the person who killed, and the defense has the capability to prove that the situation and the lighting and the distance between the incident and the witnesses were not very clear that this is the person who killed. They cannot witness. So the credibility, on damaging the credibility of the witnesses, how many witnesses you bring, once credibility of the witness is damaged by some reason associated with the crime, then obviously the other party is going to win. The defense is going to win, right? The prosecution would not win. So evidence is to be weighed and not counted. How many members witnessed the case is not very important. Even if it is a single witness, if the witness had seen the killing directly, very near, then it is a case. It is a very good case for convicting the person. Next. Which one of the following is not a prerequisite of the presumption as dowry death under section 113B of the Indian Evidence Act 1872? So we all know in our previous sessions, as we have gone through, that presumption as to dowry death, once a person has been died, a girl who married and she died within a period of 7 years, it is presumed that the family, the husband along with the relatives, have killed them. So it is presumed in such a way according to section 113B. So the question here is, which one of the following is not a prerequisite? So the conditions for section 113B need to be verified. Victim was subjected to cruelty or harassment by her husband or relatives. Yes, this needs to be tested. Victim has illicit relationship with other male person. This need not be tested. This not be testified by any witnesses, or this not be tested at all. Right? So this is not a prerequisite. Not in all circumstances, the victim who died had an illicit relationship with some other male person. So that will kill the sanctity of the victim. It will be an unjust situation wherein the court, if it would put it as a condition to test if the victim had an illicit relationship with other male members. So that is the reason this is not a prerequisite. Such cruelty or harassment was in connection with any demand for dowry. Obviously, dowry is an important point. So because section 113B deals with only dowry death, it doesn't deal with any other kind of death. Next, it was done within a period of 7 years of marriage. Yes, 7 years criteria is very important. Next, which constitutional amendment introduced the anti-defection provision of the Constitution of India? Anti-defection. 52nd Constitutional Amendment. So this inserted the 10th schedule to the Constitution also. Next one. The Indian Constitution is dedicated to the Constituent Assembly, the Parliament, the people of India, the whole society. The answer is D, but from where do we take the answer is the most important part. The preamble to the Indian Constitution says, "We, the people of India, solemnly enact to ourselves. So the people of India enact it, give it to ourselves. We enact it, we give it to ourselves." Okay, simple. So, however, questions confuse you on this aspect, be determined that we enacted it to ourselves, the people of India. Next, the question of reasonable time for the performance of contract is a question of fact, law, fact and law, prudence. Reasonable time for the performance of contract. It is a question of fact. So why is it a question of fact? Because when a contract does not specify the time for performance, the law implies that it must be performed within a reasonable time. The reasonable time is not fixed by law, but depends on the circumstances of each. So the question of fact, on considering the question of fact, courts determine reasonable time by examining the nature of the contract, the conduct of the parties to the contract, trade usages and customs, surrounding circumstances and practical difficulties in determining the reasonable time. Okay, so this was decided in P.N. Iyer versus P.N. Krishnaswamy. 44. Every sale accompanied by agreement for reconveyance of property would not constitute mortgage by conditional sale. This statement is related to which section of the Transfer of Property Act 1882? So the answer is section 58. So section 58C particularly mentions the right of the mortgagee through by conditional sale. He can approach the appropriate court to foreclose the property. So section 58C is with respect to the right to foreclosure which is available to the mortgagee. Okay. Section 58 is with respect to the overall principle which is associated with the conditional sale. Answer is section 58. Moving ahead. A contract by telephone becomes complete at the place where acceptance is heard. In which case was this principle held? Bhagwan Das versus Girdarila. So we already saw this case previously also with respect to the acceptance. So a telephonic call, once it is heard by the other party, I call you and uh, I ask for a contract, I offer something to you, and in response to the offer, you say that yes sir, I am okay with the contract, I accept. Then I hear that. Then it is convinced that a contract has been established. If you say yes, I accept, sir, but I don't hear it, there is some network issue, or I'm traveling and I'm not able to hear it, and later on you cut the phone or you don't hear my voice later on, and I don't hear your voice later on, and I cut the phone, and thereafter we don't talk for a long period of time, and you expect me to do something uh, on the condition which we discussed on the offer and acceptance, that does not mean that I accept it. I need to hear your acceptance, and I need to say, okay, okay. We need to get it clear that I heard you saying yes. So that is the principle underlying this acceptance by telephonic call, and this was discussed in the particular case. 46. A and B enter into a contract due to a mistake. They enter into a contract due to a mistake that a particular debt is time barred. The contract is void. Obviously, they enter into a contract due to mistake, void. 47. A proposes by a letter to sell house to B. So A sends a letter to B giving an offer to sell the house of A, okay, on a certain price. So such a communication of proposal, when is it complete? When is such a communication complete? So it is when B receives the letter. It is not that you can say that you posted the letter and the offer has been done. No, it is only upon the receipt of the letter by B, such offer is a valid offer. Basically, it is a valid proposal. If you need to understand more on this, I would just want you to pause on this explanation and then move to the next question. It is very simple to understand, not a big issue for you. An agreement is in restraint of trade under Section 27 of the Indian Contract Act 1872 is valid, voidable, void, enforceable. So an agreement is in restraint of trade under Section 27. Valid, voidable, void, enforceable. So it is void. So what Section 27 says is every agreement by which anyone is restrained from exercising a lawful possession, trade, or business of any kind is to that extent void. Okay. Next question. An agreement to do an act impossible in itself is void. We already saw that impossible acts, immoral acts, all these acts are void in nature. The interpretation clause of the Indian Contract Act 1872 has been provided in section 1, 2, 3 under none of the above. The interpretation clause is mentioned in section 2, whereas section 2 gives definitions of various terms so that you can interpret terms which are mentioned in the various provisions in the Indian Contract Act. Okay, so the purpose is clear that it is an interpretation clause. So with this, the session ends, and this is your homework question. Continuing guarantee has been defined under which section? If you had read through the Indian Contract Act contents, this question would be very easy for you, because the contents page itself says section 129 hyphen continuing guarantee. Simple. To understand what a continuing guarantee is, so it is a guarantee which extends to a series of transactions, which is called a continuing guarantee. This provision addresses the nature of a guarantee that applies to multiple transactions over time rather than a single transaction. So with this, I end part 11 of our 50,000 multiple choice question series. I want you all to share this to the students and your friends and juniors who are preparing themselves for these exams. It will really benefit them a lot, and yourself too. And if you have not subscribed to my channel, I want you all to subscribe to it so that you would receive notifications as and when I post a video. It is not always that you keep online, right? You might be in your own course of work. In case a notification pops down on your device, you can watch it whenever you are free. So that is the reason I want you to subscribe to it, and see you in the next interactive part of part 12. With that, signing off. Take care.